For the personal services contract, does it have to be between parent and child? I'm childless, so can I have like a niece instead? So for the video that I posted initially, replying to the comment, it was from a child. So I believe I was addressing it in that comment as a contract that would be between a parent and a child. However, no, it does not have to be between a parent and a child. You can choose whoever you want to be the caretaker under a personal services contract. It can even be a spouse. Of course, it can be a niece, a nephew, another family member, a close friend. However, I will say this. You definitely want to pick a person who you really trust. Someone who you know is actually going to be providing these services to you and looking out for you and caring for you for the rest of your life as it pertains to these specific caretaker services or other services. Because this isn't meant to just be a way to, you know, gift the money to someone so you don't have to pay it down or spend it down for Medicaid purposes, or so that it doesn't end up going to the government. But it is actually a really good tool to utilize in order to ensure that you do have someone to provide continued care and support to you. Another thing that I had mentioned in my original comment, and this is certainly true, is once that money, the money that you have the overage in assets, so you're allowed $2,000 in assets, once the overage in assets is transferred to the person who is going to be acting as the caretaker under a personal services contract, this person is also able to utilize this money by purchasing things for you, things that you need, things to supplement your living and to supplement your lifestyle, right? Because it's their money, so they can do with it what they choose. So it's also kind of nice to know that you have someone looking out for you. And if you need something to make your life easier or to make you feel better, more taken care of, then this money, of course, can be utilized for that. It just can't be given to you directly or be put in your bank account. So this is why you really want to make sure that the person who you're putting in charge of these funds, you're giving the funds to, one, they are actually going to be providing care to you to help you out, and two, that you trust them with this amount of money that's going to be transferred from you to them. Another option for people who unfortunately don't have anyone in their life that can take on this position of being a caretaker and helping them out, sort of safeguarding these funds, or maybe, you know, having some money set aside in case something is needed during the Medicaid applicant's life. If you don't have someone who you trust to do this, another option that you can look into or consult an elder law attorney about is a pooled trust. So a pooled trust is also a way that you can transfer excess assets out of your asset account, whatever that is, whether it's bank accounts, financial institution accounts, whatever it is, but you can transfer them out of the assets that you own and into a pooled trust so that they can be used for your benefit during your lifetime. The fiduciary, or the person who's managing this pooled trust, a nonprofit organization, they are able to use the funds that are transferred into this pooled trust to supplement your needs as well during your lifetime. But remember, the difference with this type of vehicle is the money that is left over in that pooled trust is most likely going to Medicaid. It's going to get reclaimed from Medicaid. It's going to go to pay for expenses that they paid for during your lifetime. The only way around this is if you do have a spouse who is on Medicaid and also needs a pooled trust. There are ways to transfer whatever is left over in your account after you pass away to your spouse. But if you're not in that scenario and you're a single individual, then anything that will be left over in the pooled trust that was, you know, benchmarked for you or earmarked for you, that would actually go to Medicaid, because they would be able to put a claim in against it after you pass away. So it is another tool though, and there are other tools. So this is definitely something that you're going to want to meet with an elder law attorney. Again, I practice in Florida, so these are tools that I'm aware of in the state of Florida, but you want to meet with a qualified elder law attorney in the state that you live in, because states are different. Some states allow certain things and some states don't. Remember, Medicaid does have different rules state by state, so it is important to consult an expert in your area, before you decide what might be the best route for you to take. All right, so I hope this answers the question. Yes, you can have that personal services contract with your niece. That's totally fine. If you have any other questions about how personal services contracts work, Medicaid, elder law, estate planning in general, and you're in Florida, please don't hesitate to contact our office or atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.